ADEA plaintiffs can prove their case through either disparate treatment or disparate impact analysis. So in that sense, it is similar to Title VII claims. There's some key differences, however, in terms of disparate impact, which we'll focus on when we get there. But when we talk about disparate treatment, it's very similar to Title VII in its application. So again, you start with the prima facie case. The prima facie case is going to be very similar to a prima facie case under Title VII. You have to show that you were in the protected class, meaning over the age of 40. You must have suffered some adverse employment action, firing, termination, lack of loss of benefits, loss of wages, that the plaintiff was qualified for the position, and that the plaintiff was being treated differently than a younger worker, that a younger worker did not face the same treatment as an older worker. So this is the prima facie case for disparate treatment. The mixed motive analysis, however, is not relevant to an ADEA age discrimination claim. The mixed motive analysis, you may recall when we talked about sex discrimination, the mixed motive analysis originally involved an analysis to see which was the greater motive for the discriminatory act. That was it based on an illegal motive of, say, sex discrimination, or was it based on a legal motive of experience or productivity? That was all changed in the Civil Rights Act of 1991, which removed mixed motive as a defense, which is to say, under Title VII, if the reasons for the behavior for the illegal discrimination had anything to do with an illegal reason, then the entire decision is illegal. So if 99% of your decision to discriminate against this person was based on legal factors like experience or productivity, and 1% was because it was a woman, that makes the whole decision illegal. That is not the same case for the ADEA. That under the ADEA, you can consider age as long as it's not the predominant reason you took the action that you took. And this is why it's so difficult to prove an ADEA claim. Now, most courts had treated mixed motive under the ADEA similar to the rules of Title VII. That 1991, the Civil Rights Act was passed, and that said that consideration of any illegal factor made the whole decision illegal. Well, most courts had treated age discrimination in the same manner, that if you considered age, then that made the whole decision unlawful. But in 2009, we had a case that went to the Supreme Court, and in that case, the court said, hey, Congress changed mixed motive for Title VII in 1991. They could have chosen to change the ADEA, but apparently chose not to. Therefore, the ADEA is not to be treated the same as Title VII. So what this means from a practical perspective is you must show that the act that took place was based primarily on age and not simply that it was one of the factors used. You have to show that it was the predominant factor that led to the unequal treatment. If the employee makes the prima facie case, the burden of proof shifts to the employer. The employer is going to respond with legitimate non-discriminatory reason, LNDR, same as before. The ADA, however, also provides for the BFOQ defense, the bona fide occupational qualification defense. Now, when we were talking about the BFOQ, we said it's not available at all for race or color. It's slightly available for sex, but almost never. it's a little bit available for national origin, but it's a lot available for age discrimination. Age is one of the most broadly applied BFOQs. And the reason why is that the standard for BFOQ for age is slightly different than the standard for Title VII claims. The employer's proof of a bona fide occupational qualification under the ADEA is easier than proving the BFOQ under Title VII. Title VII, just to refresh you, how do I prove a BFOQ? Well, it requires that the employer demonstrate the essence of the business requires the exclusion of the members of a protected class, meaning it goes to the heart of my business. If I am not allowed to discriminate on this basis, then I'm going to go out of business. So you must show that it requires the exclusion of members in a protected class, and you must show that all or substantially all of the members of that class are unable to perform adequately in the position in question. Meaning, I must hire men for this job, as an example, because all women have some disqualifying factor that makes them unable to perform the job. All or substantially all. So that's a very hard standard to get back. How many jobs are there where you can say that all men are unable to do this job? Well, with age, the standard is much easier. Under the ADEA, the employer has to prove, first of all, the age limit is reasonably necessary to the essence of the employer's business, and either the same, all or substantially all of the individuals over that age cannot do the job adequately, or some of the individuals over that age possess a disqualifying trait that cannot be ascertained except by reference to age. Meaning that if some of the members of the protected class have some disqualifying trait, then, and we can only ascertain that trait by reference to age, then I can arbitrarily eliminate people over a certain age. If I have a trucking company, for instance, and I have a trucking company, I hire commercial drivers, and I have a policy that I don't hire anyone who is over 70 years old. And the reason for that is that once you are over 70, your night vision becomes worse, and therefore you are more likely to get into an accident and cause harm. In order to establish a BFOQ, I don't have to establish that everyone over 70 loses their night vision, or substantially everyone over 70 loses their night vision. Instead, I can say that some people over the age of 70 lose their night vision, and the only way we know who those people are is by looking at their age. So what the result of this is that it's easier to craft a BFOQ related to age because you only have to show that some older workers lack the skill that younger workers have. So the BFOQ much broader under the ADEA. This last element allows an employer to exclude older workers from a position that may be safe for some older workers, that in fact may be safe for all older workers, or substantially all older workers, a majority of older workers. But if I can show that some older workers can't do that job, then that's enough to establish a BFOQ. So much easier to establish BFOQ for age. This case, Western Airlines versus Criswell, involved an airplane pilot. Now, until very recently, commercial pilots could not fly commercial aircraft once they had reached the age of 60. that 60 was the maximum. At 60, you lost your license. And this was an arbitrary rule that had been put in place, decades before, under the belief that, well, at some point, you're not as experienced as you were before. I mean, you're not as young and spry, and therefore you can't fly a plane. Arbitrary rule. Nevertheless, it was the rule, and so no airline allowed a pilot who was older than 60 to fly. Now, by the way, that was just changed pretty recently to raise the number to 65, but 65 is still the current age limit for a commercial pilot. Once you become 65, you can no longer fly planes commercially. In this case, this was back when there was a 60-year-old limit, and Western Airlines would hire pilots who could no longer be pilots. They would hire them as a flight engineer, which is the third pilot on long transatlantic trips. They don't have to have the ability to be a commercial pilot. They just have to be there in cases of emergency. And Western Airlines would hire pilots who were still perfectly capable of flying planes for these flight engineer positions. But they also imposed a limit of 65. Again, arbitrary, not sure why they picked that number, but it seemed, the idea really was this will ease you out of your job into retirement. This will cover that 5 years between the time you stop flying and the time you actually retire. Mr. Criswell was slightly older than 65 and was terminated when he turned 65. And there was no reason why he believed that he was any worse at the job now than he was 3 months earlier. So therefore he brought a case against the employer. The employer responds with the idea of BFOQ. Something happens to older people. They become less capable of being commercial pilots. We don't know what that age limit is, but we think 65 is a reasonable number. Some pilots over the age of 65 are unable to do this job. Therefore, the ADEA says I can exclude all of the pilots over the age of 65 from this job. Now, you may have heard about mandatory retirement ages. Mandatory retirement used to be a thing. Many employers would require you to leave at the age of 65. Many employers would require you to leave at 70. The idea is you move on and they're allowed to bring in younger employees, newer employees. Well, the mandatory retirement age has been eliminated for most private sector positions. You cannot have that age. Disparate impact. Disparate impact is much harder to prove under the ADEA than under Title VII for the reasons we'll talk about. Now, an ADEA plaintiff can still bring a claim based on disparate impact, but it's difficult to establish, meaning there is some neutral policy that has a disparate impact, a disproportionate impact on older workers, and therefore I am entitled to bring a claim based on this disproportionate impact, these statistics. The problem is that courts view statistical-based disparate impact claims with a lot of skepticism. And why is that? Because if you were to look at any policy and then you were to examine what happens with the company, you would see that older workers are always being replaced by younger workers, or almost always. That if we want to look at statistics, invariably, every employer's statistics will skew in favor of younger workers because that's how the world works. People leave the workforce and we hire younger workers to replace them. So therefore, any statistical claim is going to be suspect because it's the same thing happens whether or not the policy was there or, at all. Meaning older workers are always going to be replaced by younger workers, and maybe it's got nothing to do with this particular neutral policy, Maybe it's just the way of the world. So anytime you bring a disparate impact claim for age discrimination, it's going to be suspect. Furthermore, disparate impact claims require that intent, meaning you have to establish a discriminatory motive. This policy was put in place to discriminate against older workers. This facially neutral policy was put in place only to harm older workers. So you have to prove intent even on a disparate impact claim. And finally, the thing that makes it so hard is that in an ADEA disparate impact claim, you don't have to establish business necessity. Remember the ordinary defense to a disparate impact claim, the employer establishes business necessity. It was necessary for my business. Well, for age discrimination claims, the employer has a defense known as reasonable factor other than age, RFOA. And what that means is I don't have to show that it was necessary for my business. I just have to show that my business is going to do better with this neutral policy that has a disproportionate impact. And as long as it's a reasonable factor, then that's permissible. So the RFOA defense is different than business necessity. What we see under RFOA are things like economic concerns and seniority plans. A few years back, there was a chain of appliance stores called Circuit City. You may have heard of Circuit City. You may have seen their abandoned buildings. They all went out of business in the financial crash of 2008. Now, Circuit City had been doing poorly prior to their final bankruptcy. And so they brought in a new CEO to take charge of the entity, the company. And the first thing that the CEO did was he fired everyone who had been working at the company for more than 3 years. Just fired them all. If you worked there for more than 3 years, you got fired. That's a facially neutral policy, but it's going to have a disproportionate impact on older workers. Older workers are more likely to have been there for more than 3 years. So they brought a claim. This is disparate impact. This is a facially neutral policy that has this disproportionate impact. But the employer, Circuit City, was able to respond as like, look, people who have experience are making more money. They've had raises. And we can save millions of dollars by firing everyone who's been there for more than 3 years. Yes, it's going to have a disproportionate impact, but this is reasonable for us to do in light of our particular economic concerns. So in an ADA disparate impact claim, it's much more likely that you can establish RFOA. This case, Smith versus City of Jackson, this is a case that went all the way to the Supreme Court and involved the police force in Jackson, Mississippi. And the police force in Jackson, Mississippi faced a problem that police forces all around the country face, is that they would hire new employees and they would have to send them to the academy, so they have to pay them while they are training. And then they're going to be put on the job, and their first 2 years of the job, they're going to be doing a lot of on-the-job training. They're going to be becoming more familiar with police work. And the problem is, though, is that after 2 years, you are much more likely to change your jobs because now another police force much more likely to bring you on because you've got 2 years experience. And they don't have to go through all the academy and all the training and building of experience. They can just hire you straight away. And so what the City of Jackson found themselves dealing with was an exodus of people who left after the first 2 years. Now they also noticed that workers, law officers who had been there for 5 years or longer tended to stay. So really it was that 2 to 5 year period of experience when officers were most likely to leave. So what the city of Jackson did was they put in a raise policy, and the raise was a certain amount for those with 0 to 2 years of experience. And that was the same amount for workers with greater than 5 years experience. But it was a higher percentage for those workers who had been there 2, 3, 4 years. They got a higher raise than people outside of the protected class. And so what does that mean? That means that this is a neutral policy. 2 to 5 years, you get a good raise. More than 5 years, not such a good raise. Neutral policy, but it's going to have a disproportionate impact on older workers. Older workers more likely have been there for a longer period of time. The case goes all the way to Supreme Court. And ultimately, the Supreme Court agrees with the city of Jackson. This is a reasonable factor other than age. They were worried about losing their investment in these new employees, and therefore it was justifiable that they had a policy that paid people more if they were in that category of people most likely to leave. So from an employer perspective, understand that your ability to put into place policies that have this disproportionate impact is much easier under the ADEA than under Title VII. The employee responds with proof of pretext. Remember, pretext is showing that the reason or defense that was altered is actually pretextual, that it was not serious, that this was not about seniority concerns or retention plans, that this in fact was about age. And you can show pretext in a number of ways, meaning you look at direct evidence, conversations or emails or letters. Or you could look at indirect evidence, meaning they thought about it, they indicated that they thought about it, they realized it was a possibility, and they were willing to do it just to affect the policy. The pretext, again, rarely comes up in the disparate impact case because it's so easy to overcome the presumption of discrimination by showing RFOA, reasonable factor other than age.